Welcome everybody to the meeting. The members of the subcommittee. I guess we're missing Steve Robertson also. Brian?
Yes, we are. And I don't know if he has responded. I'll check on that, but I think we can still proceed. We certainly have a quorum.
And would like to welcome everybody to the committee. We have our past president, Colin Willoughby, and we have our Vice President, Marcy Armstrong, and President-elect Darren Jordan. I guess I just got that, the order of that a little bit reversed, but I'd like to welcome all of our officers and our advisory members, the participants, Judge Tessa Sellers and David Allen, and Mark Enriquez is also joining us as participant. And so, Brian, I must confess that I do not have the conflict statement handy. Are you able to read that for us?
Yes, I am. I believe what you are, if you give me just 1 second, I believe what you're referring to is that you would like to advise members of this subcommittee of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict.
Thank you, Brian. That was exactly what I had in mind.
I figured.
And so at this point in time, we'd like to turn this over to Brian to give everybody an overview of where we're at on this 19 FEO 4, I guess, that's been around a long time. And I guess Judge Robinson knows that better as well or better than any of us. So if you will, Brian, if you can take us through that, please.
Absolutely. Thank you, Jerry. Yeah, thank you everybody for joining us for this discussion today. As you all recall, this subcommittee has met. This subcommittee has had a number of different lineups. Those lineup changes have occurred for a variety of reasons, including folks rotating from ethics to grievance, or some becoming officers of the state bar. So we've still been wrestling with this issue for some time. In October of 2020, this subcommittee recommended for publication proposed 2019 formal ethics opinion for dealing with communications with judicial officials. That opinion is in your materials. It's at the very outset of your materials. And following that opinion in your materials, you'll see the list of comments that we received on the opinion. Generally speaking, the comments were negative, or I guess unfavorable to the opinion. A number of comments noted some of the impracticalities of some of the opinions, the conclusions reached in the opinion, and some just felt that some aspects needed to be clarified. Of course, there was one opinion or one comment received that was positive. This was an attorney that I believe was practicing in Florida for some time before moving to North Carolina, and found it very strange how he thought that a lot of North Carolina lawyers were engaged in a variety of ex parte communications based upon the different practices or practice areas in the state. And so he expressed, I guess, a significant approval of the opinion. That being said, based upon the comments, this matter was referred back to this subcommittee at the January meeting by the Ethics Committee to take a look at the opinion and see what, if anything, in the opinion needed to be changed in terms of the analysis. Just as a general overview, so we're all on the same page, you all know that this opinion is dealing with communications with judges, and particularly Rule 3.5. We were originally trying to write one opinion that would really be a kind of a single go-to source of guidance for lawyers in dealing with communicating or dealing with the issues that arise in communicating with judicial officials. As the opinion recognizes, and I think this still stands, we have a body of ethics opinions dealing with this topic, and those ethics opinions at this point have kind of created a confusing body of ethics opinions and a confusing set of guidance, because those ethics opinions were based upon different iterations of Rule 3.5, particularly as they relate to ex parte communications. So this opinion was really trying to kind of summarize and address the general topic, which of course it's a very nuanced topic of communicating with judges, and really trying to set out the clear, obvious answers from the more difficult and maybe just unclear informal communication issues that we see in today's practice, particularly with regards to text messaging and email communications. There's a lot to talk about here, and I don't want to go through the entire opinion because I presume everybody remembers the work that the subcommittee did, as well as has read the former opinion. But based upon the comments that we received, Carmen and I went back to the opinion and revised the opinion. And the revision is based upon a prior analysis that this subcommittee looked at last year. As you all may recall, I believe this was an August meeting or maybe a September meeting of last year, that we were discussing this issue, and particularly discussing inquiry number 4, which deals with this question of kind of what's the result when a lawyer sends a simultaneous communication, copies opposing counsel when sending this communication to a judge via email or text message, and trying to understand is that an ex parte communication under the definition of ex parte communications that we have now in Rule 3.5. Under the old version of the rule, that type of communication, texting or emailing a judge, copying opposing counsel, would have been exempted from the 3.5, or excuse me, the ex parte communication prohibition, because the old version of 3.5 specifically accepted communications that were simultaneously copied to the opposing side. And that exception no longer exists in Rule 3.5. So we, as a subcommittee, had discussed kind of 2 options for that particular inquiry. And really, it kind of comes down to one of 2 defaults, if you will, as far as how we address these things. One analysis was to say, when a lawyer sends a communication to a judge and copies the opposing side, that would be an ex parte communication, and therefore would be prohibited unless the judge says that type of communication is okay. The other analysis could say that a lawyer sending communication to a judge by email or text message or what have you in writing and copying the opposing side would not be an ex parte communication, because simultaneously providing that communication is essentially making the communication in the presence of that other lawyer. And it's only prohibited if the judge basically instructs the lawyers to not do that anymore. So it's kind of one of 2 defaults. And this subcommittee debated that issue a fair amount, and ultimately came down on the former analysis, saying that it should be prohibited unless the judge says it's okay. That was really, I think, the crux of the negative comments that we saw based upon this opinion, or from this opinion. And that's really where I think one of the largest parts of the revision, or the revised opinion, focuses. The inquiry number 4 essentially flips that analysis, and we have a new opinion to kind of address, or at least consider here today. So there's some other revisions. Again, I think we can get into the details of the revisions. One of the other biggest parts of the revised opinion is the introduction, which I think really maybe confused things a bit more than they were intended to. So Carmen and I rewrote the introduction to hopefully provide a clearer sense of where this opinion was coming from, the context of the opinion, where it was going. And then we can get into the different inquiries. But I guess I'll kind of stop here. I know I've said a lot of words. I'll stop here and just kind of say that's where we are at right now. I think we need to determine, do we still like the old opinion, even in light of those comments, and perhaps discuss some of the comments. And if we decide that we want to revise the opinion, how do we revise it? Do we go with the revision that staff has presented? Do you want to take it in a different direction? I think one question that is potentially lingering out there is, should Rule 3.5 kind of be amended to include that simultaneously provided exception that it once had. I will tell you personally, I would prefer not to amend the rules if we don't need to, but I think that's something that is at least up for discussion if anyone wants to bring that up. So like I said, with all that said, I will kind of turn over the discussion to Jerry to shepherd us through how we want to proceed here. But before I do that, let me just kind of make one other mention of the materials. At the very end of your materials that were sent out are the Ethics Committee agendas from 2017 when Rule 3.5 was amended. And that was something that I know there was some question about. Well, when we amended Rule 3.5 to remove that simultaneously provision, or the simultaneous provision exception, what was the intent there? And you know, what was the thought process behind that? And you'll see in these different minutes from the subcommittee meetings, I don't think it was, at least it wasn't reflected in the minutes, that it wasn't specifically addressed. I asked some of the other staff folks that were around and attended those meetings if they recalled specific conversations or expressed intentions, and there was no recollection that we could really uncover. So I think it was just kind of an overhaul of 3.5 and looking to define ex parte communication in a helpful way. But that being said, I just wanted to make note of those particular materials at the very end of the PDF, should you wonder why are those here. So with that said, Jerry, I will turn over to you to start our conversation.
So first, I guess we should probably see what the thoughts are from the subcommittee members themselves and other folks, the advisory participants and the other folks attending the meeting may also want to discuss it. Judge Robinson, I guess in terms of seniority on this subcommittee, you're the most senior member. What are your thoughts with regards to the new rewrite of Inquiry 3? We can't hear you, Judge.
I apologize. You know, I saw somewhere recently that one of the most common phrases in 2020 into 2021 is "you're muted," and I'm guilty of that. Let me make an observation, if I could, just generally about where we are. One, I wish we could put this to bed, and I hope we put it to bed this afternoon. Secondly, to the extent people are advocating directly or indirectly for a modification of what the definition of ex parte is, I'm opposed to that. I think the definition we have in Rule 3.5 is important and it's clear, and it says, and it's always been my understanding as a practicing attorney before I got on the bench, that ex parte meant when one side was communicating with the judge and the other side didn't have an opportunity to do so at the same time. Unless there was some unusual circumstance that permitted otherwise, the assumption was that for justice to be done fairly and impartially, that both sides had an opportunity simultaneously to be before the court. And so as it relates to what we're talking about in this opinion, I have been, I think, consistent in saying that I believe as long as a communication with the court is simultaneous, that is, if somebody gets in a wreck and needs to email the court and tell them that they're going to be late or unavailable for a hearing, as long as opposing counsel gets that communication, that is sent that communication at the same time by email that the court is sent, or is texted at the same time that the court is sent the text, that should be sufficient. And that is one of the commentators who wrote in said, at some point, we have got to rely on the practicing bar to be honorable about this and do what's reasonable under the circumstances. And if they abuse the system, there is a way to deal with that. That's point number one, I guess. And most importantly, I was intrigued by Robert Fuller's comments about what, he said if you require prior notice in order to be able to send a communication to the judge, I asked the question, what constitutes prior notice? That is, as I understand the way it's now posited, if you get in a wreck and, okay, you can't send an email to the judge without advising opposing counsel that you're going to send an email to the judge, okay, is 5 minutes enough? Is an hour the minimum? How do we police that issue? Or are we going to say the other side has to actually receive the communication advising them that they are going to communicate with the judge in order for it to be appropriate? As I think you all know, because I've said it until you're nauseous of hearing it, we have to have the ability to communicate by email in the business court. That's just the way we're wired. And so we have provisions in our rules that expressly permit that. And so as a fallback position, I think it ought to provide at a minimum that if the court deems it appropriate and puts that in their local rules, that would be sufficient and would protect attorneys as long as they copied opposing counsel on communications. That's more than you want to hear, but that's the way I think about it.
Thank you, Judge. I think that reflects a lot of the comments that we've actually received. The Honorable Todd Brown has been noticeably quiet. Todd, did you have any discussion that you'd like to offer on it?
Thank you, Mr. Chair. I don't have any particular observations. I wanted to get up. Obviously, I'm new to this committee, and I have not had the fortune of having the knowledge and education that you guys have had as you have grappled with this rule. I guess I was trying to think through, and maybe someone knows, the setup for the smaller counties and how, and can you, for example, in Mecklenburg or business court, I know Judge Robinson is exactly right. You send, there are specific rules which direct you to deal only with the trial court administrator. And even in the business court, I think that the judges want you to copy every single lawyer on every single email that you might send to the court. At least that's been my experience down here in Charlotte. And so I'm trying to understand the setup. Does every county have, a trial court administrator that you can send an email to or text to? And I gather that the answer to that is no. I suspect that there's some smaller counties perhaps, and maybe some larger ones that do not have local rules, for example. And if that's the case, I mean, how do you know who else to contact, who to contact, or whether there's some document in a smaller county that maybe some senior judge has written to say, this is how you communicate with the court? It's pretty clear in the business court, it's pretty clear, in Mecklenburg, Wake, that the rules are pretty clear about who you never contact the judge directly. But I was sort of thinking through it again with not the benefit of all the education you guys have had and study you guys have had about, is there something, that we can put in these opinions that might, because the opinion sort of, and I guess the rule 2 sort of focuses on communicating with judges, can we, could, for example, there'd be something put in these rules which say if you have to communicate in an emergency situation, you communicate with the judge and the trial court administrator and opposing counsel, or just whoever the designated persons might be. But I guess the looming question I had is it possible to do what we're trying to do in this rule? Does every county have someone that if I'm in an accident that I could communicate with rather than the judge if I need to communicate with the court? Does someone know the answer to that? I mean,
I do not know the specific answer. I'm not familiar with every single district. I do know that I've dealt with other districts in my prior role at the bar where, you might have a You might have a clerk or a TCA or just a judge's assistant that, you know, may not be where the judge is on any given day because they're in one county and the judge is in a different, you know, and all that stuff, and even within the district. And so it doesn't really lend itself to a very helpful or practical sort of structure. I don't know if every district has or is required to have, for that matter, a TCA. Everybody has a clerk, but I don't know if everybody has a superior court judge's assistant or what have you. I'm just not entirely sure about the personnel. I don't know if anybody else has any opinions otherwise.
Well, I can say from the 30th judicial district, we do not have the ability to, we have 2 judicial assistants that are in Haywood County, and our district is 7 counties large. So I may not see a judicial assistant in my office sometimes for a month or longer. So to try to communicate if I'm in Graham County would be quite difficult for that to be the point contact for that to happen on any given day.
And it takes 2.5 hours to drive across our district. So
That is correct.
that's several mountain ranges that you cross.
I mean, so I don't have the answers, but I just saw, and I'm still trying to wrap my head around all of it, not having the benefit of being on the committee forever as you guys have. But when I read a couple of the inquiries, the one about being in an accident, and if you send an email to the judge and you send an email to opposing county, that still is not sufficient. That gave me pause. I understand the reason behind the rule, and I understand that, sorry guys, let me cut this off. I understand the reason behind the rule and how you want to have the rule applied consistently and as written, but I would think to Judge Robinson's point that at some point, you know, lawyers, officers of the court, and is it sufficient if they can prove that at the same time I was in this accident, I had 5 minutes to send a text message. I sent a text message to the judge and to the opposing counsel, and then they wheeled me off in the ambulance. I mean, is that not, is that, are we going to say at the bar that's a rule violation? Apparently we are. So some of these things trouble me. And again, I apologize. I don't have the benefit of hindsight. I wish I did, but I understand why the rule initially said, no, you can't do it. It's still a violation, because I understand that the point that just because you send a text message or an email does not mean the person's going to get it. And I get that. It also doesn't mean the judge is going to get it. I mean, and so at some point, do you default to the lawyer being an officer of the court and having a code of ethics that he or she needs to comply with? And if they try in good faith to notify the judicial officer presiding and opposing counsel, is that sufficient? And if it's not, are we really at the state board going to discipline somebody for doing all they could do, quite frankly? Because based on what we're saying and the way the rule is written, if I'm in an accident and I text the judge and I text the other side, I still have violated the rule if I read it correctly. And that gives me pause. So I'll stop there and shut up. I don't know if that made any sense, but it's just, and I've read through these a little bit, and some of them give me pause and some of them are perfectly fine with me.
And that brings in not only inquiry number 3, but also inquiry number 4 and the opinion on it also, I think, Todd.
And maybe 5 too. I forget the numbers, but I thought several of them sort of had the same emergency situation. I think 5 deals with emergency situation as well.
And also, Todd, one thing on one of your earlier points, the opinion to the new inquiry number 3 does provide, that has the catch-all whether or not the communication would be prohibited by a local rule. if there was a local rule that required communication with the TCA or something like that.
And a lot of us know that a lot of our judicial districts do not have local rules.
Well, for example, in the 3rd Judicial District, we have in district court, we have local rules, but they don't address communications with judges as far as I know. And in the Superior Court, Judicial District 30A, we have local rules, of course, but they also, as far as I know, I don't recall anything that addresses communications with the judge that requires anything in particular.
The other thing I meant to ask too, and I hope I'm reading the latest iteration of this rule. It's the one I think, Brian, that you sent out a day or so ago. Is that the latest? Because you said something about it's been revised. Is there a red line version that you guys are looking at that I'm not looking at? Or is it what you sent out the last couple of days, the latest iteration?
Yeah, their red line version is in the materials. It's right after I provided a clean copy, and then the track changes version.
Okay, I think I'm reading the right one then. Thank you.
Yeah, and I see Marcy's got her hand up, and I think maybe after Marcy's comment, I was going to say to offer, I guess just maybe it might focus our discussion here if we can take a look at the new opinion, or at least the proposed revision, and maybe even look at the red line version, so I can walk us through exactly what has been removed and what has been revised in the sense of kind of highlighting this is what we previously said, and we can determine if we want to continue to say that or go with a different statement. Marcy, I see you had your hand up.
Okay, very quickly. First of all, this has been a very interesting exercise to try to come up with a rule that fits business court, domestic court. Most of the comments were, like I saw, workers' comp, lawyer, criminal. And it's tough because we all live in a different world. I know that I'm in a 3-county district, and if we are going to be late, we just email the clerk that's in the courtroom. I mean, it's just that simple. She's in the courtroom. We know who it is. We send her an email and say, tell the judge we're on our way, we're running behind or whatever. And I know that's how we deal with Johnston, Harnett, and Lee County. We don't have a TCA, but there's a clerk. There's a clerk in every courtroom. So that's how we handle it. And you didn't get any negative feedback from any domestic lawyers, because I think one of the biggest concerns when we first started this whole process, and I wasn't on the committee originally, is lawyers that thought that just if they copied opposing attorney, it was okay to argue their case. It wasn't just to email the judge about I'm running behind. I need a continuance and my child's sick. I mean, so Brian, like your changes. First of all, I do think we need to be reasonable about this, and I do think if you have somebody that's been in a wreck, as long as if the only thing they don't have the clerk's text or the clerk's email, and all they have is the judges, as long as they copy the opposing attorney and say they've been in a wreck. I mean, that makes sense to me. I just think that whatever we put out there has to make abundantly clear that you cannot argue the substance of your case unless the judge invites you to do so. And I think that if we make that abundantly clear, I'm okay with it. I am, but I just think that before it wasn't that clear. And we just, in the family law world, we're just having to deal with a lot of off the record junk and stuff that should not have been, we shouldn't have had to deal with, because everybody said, oh, well, it's not ex parte because we're copying opposing attorney. So as long as it's clear, we're talking about these limited situations, it's okay. And when the court invites, which I think you deal with the new inquiry 6, I think that's it, yeah. And I have questions about that, but I think you're smart to go inquiry by inquiry, but anyway, it's not been easy.
Yeah, no, that's why I think just as a launch off part, and well, I guess for a couple of things, but one, yes, Marcy, I think that part has remained the same really in both iterations. That I think the subcommittee has been pretty consistent in saying arguing the merits of your case in an informal, outside the record forum, unless invited by the judge, is not something that we want to be clear that is not permissible. That arguably that always violated Rule 8.4D, that it's prejudicial to the administration of justice, but we've just never had an opinion that explicitly said that. And so that part has stayed the same. But it's the simultaneous communications, and it really, I know it feels like it just naturally always focuses on administrative and scheduling issues. And there's been, even some question of, well, should there be an administrative or scheduling exception into Rule 3.5? And that's not there right now. And I don't think we're expressly saying that here, even though there's kind of a natural conclusion there. But what I want to do right now, I'm going to go ahead and share my screen so we can look at these. This is the revised version of the opinion that's in your materials. It's the red line version. And I'm not going to, I think I'll just kind of say this. If anybody wants to stop and focus on a particular section, please interrupt me, because I don't want to belabor the point in going through this line by line in any way. But I'll just kind of give a brief overview of what has changed in this, so we can all kind of be on the same page. The introduction, like I said before, has been rewritten, and I think that was something that we heard feedback, and also Carmen and I took a look at the introduction that we had before and realized that I think it was confusing. And I think the prior introduction was the version that was saying things like you should always direct this to the TCA or the trial court coordinator or the clerk, at least encouraging folks to do so. And that generated some comment of, what about in my county where we don't have that? And I think it created perhaps some confusion as to what was required versus what was encouraged. So this introduction has been rewritten, and really what I think the focus of the introduction is to set the stage to essentially say that there are 3 categories of communications that lawyers generally engage in. And it's here in this new paragraph that the communications are either clearly permissible, namely formal pleadings and so forth, and arguments on the record, or there are these clearly prohibited communications, like those spontaneous in-person ex parte communications that I think everybody thinks of when they think of ex parte communications. But then there's this third category of these informal communications, like emails about scheduling dilemmas, that this opinion focuses its analysis on. You'll see that there's these little blurbs about kind of, the notion that formal communications, official on the record communications, have always been permissible. This really is brought up from what was previously inquiry number 1. Inquiry number 1 of the old opinion had an answer that basically kind of said, can a lawyer file a motion to continue with the court notice, or with a copy to the opposing side? The answer was obviously yes. And the inquiry wasn't really answering an inquiry or a legitimate question. It was just kind of setting the foundation for the rest of the opinion. And we realized that brought about some comment too about, well, why do you even need this particular inquiry? So we brought that into the introduction, again, to serve as the foundation for the opinion. Those formal communications are always permissible. And then there's, of course, a comment about, or some language about, why does 3.5 exist, or particularly the prohibition on ex parte communications? Why does that even exist? And it's to ensure fair and equal access to the presiding tribunal by the different parties and their representative counsel. So again, these are foundational statements for the rest of the opinion. And then we get into the scenarios. Like I said before, inquiry number 1, or what was old inquiry number 1 and opinion number 1, very broad, very kind of obviously this is the answer, and it's been moved into the introduction, so that has been deleted entirely. That puts us in this spot where the very first inquiry of this new opinion is addressing the question of whether or not a lawyer can essentially having some sort of last minute scheduling dilemma, if they can email or text the judge without copying opposing counsel. And the answer to that is no, that you can't just send a direct communication to the judge with your scheduling dilemma, because that is going to satisfy the definition of ex parte communication. You would have to copy opposing counsel, which we get into in a subsequent inquiry. But just answering the direct question, I haven't copied opposing counsel and I'm communicating with the judge, about the matter over which this judge is presiding. Is that permissible? And the answer is no. That is the same, essentially the same analysis as the prior opinion. Same thing with the next inquiry. What is now inquiry number 2 and opinion number 2. Kind of if you've got multiple matters on for any given day, and I just send my communication to all the judges, but I don't copy any of the other opposing counsel. Still the same issue. You can't do that. If anything, you've just engaged in multiple rule violations. But then when we get down to in what is now inquiry number 3 and opinion number 3, this is where we have the simultaneous communication issue. And I guess I'll just pause and say, I think those first 2 inquiries I just went over, I don't think there's any changes, there's any taste for this subcommittee to change those particular analyses. This next one is where we have the biggest or the most significant change. Previously, the scenario, or I guess I should say that the scenario in the prior opinion was that, essentially lawyers informing the court of their inability to attend a particular hearing, and now they've copied opposing counsel on the communication to the judge. The prior answer was no, you can't do that. That's not, or that is ex parte. You are not communicating in the presence of the opposing party or the opposing counsel because of this notion that simultaneous provision does not necessarily mean simultaneous receipt. That was probably the most criticized aspect of this opinion. So the new version says, yes, you can. The new version reasons that this definition for ex parte communications, that essentially if you make a communication outside the presence of the opposing party, that's one of the steps to satisfying ex parte communications. But when you simultaneously provide it or copy the opposing counsel on it, you are essentially making the communication in the presence of the opposing counsel or opposing party. So now that type of communication under this opinion is permissible. Now, the opinion goes on to encourage lawyers to remember that sometimes, simultaneous provision doesn't mean simultaneous receipt. So when it's possible, when it's appropriate, try to give notice to the opposing party that you're going to engage in this direct communication with the judge. But again, this is encouraging, not necessarily requiring, as the prior opinion did. But also the opinion goes on to note that even if something doesn't qualify as an ex parte communication, it may still be against the local rules or administrative orders or just the admonishment from the presiding tribunal. It's essentially recognizing and reminding folks that judges have the authority to deal with their attorneys. And that's something where we cite the statute there, that the statute cited 84-36 says that nothing that the state bar is doing is supposed to interfere with the court's inherent powers to deal with its attorneys. So if the judge decides, I don't want you guys emailing me directly, you need to send all of your communication through the clerk, then that's the rule that the lawyer needs to follow. So it kind of, again, reminds folks that judges can control the communications that are occurring with the tribunal. That's the biggest change for, I guess, what kind of causes a bit of a domino effect to the rest of the opinion. I guess before getting into the other inquiries, though, this is where I want to pause. And with the knowledge that in a couple of inquiries, we're going to address substantive or communications that are on the merits of the case, and stating that those occurring in these informal settings are never permissible. Just with regards to this particular opinion, are there any objections with essentially flipping the analysis from what the old opinion stated?
Hey, Brian, this is Todd. I want to comment. As you are going through these case inquiry by inquiry, I see you have addressed many of the things that I raised a moment ago. So obviously I didn't read down far enough. And based on what I have read so far and what you are saying to this point, I don't have any pause about anything you've said so far.
Okay, great. Thank you, Todd.
I apologize for not having the full flavor of the materials in front of me earlier.
Todd, you are playing catch up on years of study and debate.
I suspect I will never get there, but I will try.
Right. I saw there was a thumbs up from Mark. Oh, David, yes.
Can you scroll up just a hair on the, I can't get to my materials while I'm zooming, so.
May I offer Brian a thought?
Yes, please.
And hi, Todd. I don't know, I haven't seen you in like 25 years, but I was at Hunt and Williams years and years and years ago in the brief time he was in Raleigh. So it's nice to see you. My thought on this is reading the criticisms was that they didn't seem consistent with my recollection of what we were trying to accomplish. And so I think it was just perhaps the way it was written that came across in a way. I don't think anyone had a discussion that if you were in a car accident, you couldn't communicate as best as you could and that you would be disciplined if you didn't do it in a certain way. I think that the idea was that the preference would be, if possible, to either reach out to a court official or a opposing counsel before having these direct communications with the judge, because we, as a default rule, we want to discourage people from texting regularly with judges and emailing with them informally for a whole host of reasons. And I see that you attached my letter, which was now almost 4 years ago, so I don't know where the time is going. But I think as rewritten, it really does. I think as rewritten, it actually captures better what we were trying to accomplish, is that, look, nobody wants to punish someone for being in a car accident and having an emergency. We want to encourage certain best practices, which is if you have a TCA or JA or whoever it may be, that would be the preferable way to do it so that we can minimize direct texts and emails to judges, especially where we do have so many pro se litigants in our district courts. So, but Judge Seller's wonderful point about, they're in a huge district with lots of counties. You may not have the person you need to contact. I mean, I don't think anyone contemplated that you would be disciplined for being in a car accident and how you handled it, or that the judge would never know what happened. And I was reading that in some of the comments. So I think that I really like this new version. I think it makes it clearer. And, from a judicial ethics perspective, it's really up to us to have a good rule for judges on what they're supposed to do when they get those emergency situations. So I actually think it's really good. And I think it captures more of the essence of what we were thinking when we last met.
Great, thank you. I saw some comments from Mark and Ellen that it looks like they're looking at this version favorably. So I guess with that said, David, I know you've been reading this analysis, and I know you had some concerns with the prior opinion. Do you have any comments that you'd like to share on this particular inquiry?
No, this is, I think this is great. I was going to give you just one little bit of history because I was around with Judge Robinson and John Bruce, as I recall, and some other folks back when we first tried to do this. And first caveat, being the suck up that I am, I have to say that, of course, I agree with everything that Judge Robinson said. He is always, he's much more, he captures it much better than I. But one of the reasons that we had the discussion about simultaneous disappearing from the first iteration was that it was the committee's view that was not ex parte. And so the rule, the opinion was dealing with ex parte communication. And we thought that was the wrong place to have a discussion which involved simultaneous communication. And my recollection is we removed that. There was also a question about communicating with the court, and we looked at the judicial rules at that point, which talked about the exceptions that are some of which are covered by our inquiries here. Mere scheduling, clerical matters, those kind of things were authorized communication between counsel and the court, but that was in the judicial code that lots of folks had just sort of grafted into their sort of way of dealing with the court. But I think that's the one little bit of historical evidence we had, was that the communication was not viewed by the committee at that point that as being ex parte. But I think this is great. I'm very happy with where we are right now.
All right, thank you. Well, I guess I'll continue moving on here, the next inquiry, knowing that now the opinion says that essentially if you copy opposing counsel simultaneously, that is permitted as long as it's not addressing the merits of the case. Then we move on to what is now inquiry number 4 and opinion number 4. This is addressing the emergency situation. And this is where, you know, there's a slight change because of the prior opinion and inquiry being kind of shifted. Now the question is essentially, if lawyer gets in this emergency situation, can they contact the judge directly without copying opposing counsel, letting them know that they've been in a car accident? And the answer that's proposed here is still no. But again, it's this context is not so much even I've copied opposing counsel, but now it's just lawyer is contacting judge directly to inform the judge of this particular accident. The opinion says, no, you still can't do that, because even in an emergency situation, a lawyer should, unless authorized by law or some prior authorization from the court, a lawyer should still try to comport his or her conduct with the rules. And noting that that you should either provide notice to opposing counsel or you need to copy opposing counsel. But there's additional language that I added here to kind of recognize that these rules are supposed to be rules of reason, and that under these circumstances, opposing counsel can offer grace and understanding, and that additionally, the presiding judge has the authority to determine the propriety of that emergency communication and as the judge deems appropriate. In other words, just to send this message that technically, is that an ex parte communication? Yes, it fits the definition of an ex parte communication if you do not copy opposing counsel or provide notice. However, opposing counsel is allowed to be gracious. Opposing counsel is not required to make a big deal out of it, and to recognize the situation, as is the judge. The judge can deal with it as the judge deems appropriate. So I guess I'll pause here and ask for everyone's opinion on this particular analysis.
Hey, Brian.
Yes.
This is Todd. I have read every opinion and inquiry through opinion 5, the red line version, based on what you've said and what the judge and others have said. And I have no problem with anything that's set forth thus far.
Great. Thank you, Todd.
You've done a great job. You and Carmen and others have done a great job. So this is great. This is good.
Brian, I would chime in here just to say that I think there's some wisdom in having the answer to this question about emergency communication still be no, still be, you know, the default rule applies, because otherwise we risk getting into a debate about what constitutes an emergency. You know, if we carved out an emergency exception, that's something that I think lawyers could interpret differently. So I feel like this strikes the right balance of saying, well, it still technically is the same analysis, but everyone needs to be reasonable under these circumstances. And I from the Office of Counsel perspective, I would be deeply embarrassed to allege that there was actionable misconduct under the circumstances described in this inquiry. I mean, that's not going to happen. So that's my thought on that one.
At this time, I think it's appropriate. Judge Bell had shared a little bit of feedback with me when she was informing that she could not make this particular meeting. And she wanted to essentially say, I think particularly with regards to this opinion or this inquiry, that she would be fine receiving a communication about exigent circumstances from a lawyer directly. I think she kind of indicated that essentially the preference, of course, is that opposing counsel, you know, whether they be provided notice or at the very least that that they be copied on the communication. And she kind of referenced the notion that a lot of things are being called by WebEx. And so, you know, who is able to actually hear and the timing of these different communications, that somebody might be able to appear on calendar call via their phone, perhaps in an exigent circumstance, I think kind of, raises that issue to her that just, she doesn't want to have some rule that would frustrate moving forward, I believe is what she had indicated. But she just wanted to make it clear that under these emergency circumstances, she thinks it's appropriate for judges to contact for lawyers to contact judges about their circumstances. And of course, copying opposing counsel is, kind of I guess a given at that point.
One of the practical things that I would face in my practice here with regards to an emergency, given that I'm old and decrepit and not particularly apt on a cell phone, but I don't always have either the cell phone number of opposing counsel, and certainly if I was in a car wreck, I wouldn't have the email address of anybody available to me because that only resides in one place, and that's on my actual literal desktop. But in terms of the actual answer to inquiry number 4, Brian, I'm not certain really that no is what we're really trying to say there. I do like the last 2 sentences that you added because I think that they do capture the essence of what you're trying to get across. But it's not always possible. If I was in a car wreck, the majority of opposing counsel that I have, I probably would not have a cell number for them or an email address at that time. And I don't really know if this really, if this really clears that or not.
Well, Jerry, you raise an interesting point that has been kind of floating around in my head, and that is, if you are dealing with a situation where the opposing party is self-represented, and you don't want to give the self-represented party your cell phone number, but you have the judge's number, and you want to send this text message, in other situations, you would copy the opposing counsel's or the opposing counsel on that text message because you trust them, they already have your cell phone, etc. But you're not looking to invite that type of communication with a self-represented party. Does this, I guess, would that prevent the lawyer from contacting the judge in that situation? And perhaps that's when the communication needs to go to a third party, the clerk, or, and I guess that's kind of bringing back this question I was about to say, or do we allow that type of communication to go to the judge? But really, to allow that type of communication to go to the judge would be to carve out an exception to the definition of ex parte communications. And we're carving out an exception in the, I guess, in the ethics opinion, as opposed to the rule itself, which of course is not the preferred way that I think we deal with interpreting the rules. But I just bring that up to you now, just to, I guess, I don't know how the self-represented party plays in here, and if you have any thoughts on that issue.
And I would like to touch just a little bit on what Jerry said. Of course, I'm a district court judge in the 30th Judicial District where Jerry practices. We have about 350 attorneys in our bar. And out of that 350 attorneys, we have approximately 17 of those who do domestic work in all seven counties. And we have about 22 of them who do all of the juvenile work in those 7 counties. So we have tremendous court conflicts in reference to, you may have court in Haywood County, you may have court in Macon County as well on the same day. And especially in criminal courts, our prosecutors travel throughout the district. So for them to be able to know who to contact specifically as opposing counsel poses a different problem in our district because of the geographical issues, as well as the fact that you've got a very small pool of attorneys who are working all on the same type of cases in different counties on the same day. So I could see that could pose a problem. And as Jerry didn't point out, we have a number of attorneys who don't even have cell phones in our neck of the woods. So to communicate would be difficult from that standpoint. But I, as a judge, would rather not have them directly communicate with me.
Brian,
Yes.
this is Ellen. So I'm still a little troubled with this, and I'm very much where Todd is. I was actually, well, Todd probably wasn't reading the wrong decision, but I was when we first got here today. So I'm clearly catching up even beyond just not having been here for the last however many years y'all have. But what troubles me about the last two sentences is it's basically saying, as I interpret it, what I would tell my students is, okay, so we're saying this is ex parte, there's no exception. However, the judge can be nice about it and the other side can be nice about it, but that still leaves what the state bar is going to do about it out there. I mean, what does that tell the lawyer, you know, the cynical lawyer, the practicing lawyer in the bar about what this rule means to them?
I think it's a great question, Ellen. I think this is one of those where, you know, we're not trying to put down on paper, you know, kind of a, let's be realistic, like to what Carmen said, we would not feel comfortable prosecuting somebody for this. But this is that situation where, again, we have a, I guess, just a rule that has some pretty clear parameters. And as we've described this inquiry, the person is engaging in conduct that fits within the parameters that defines ex parte communication. And so I think it frankly, it puts us in a really difficult position of saying, you know, is it technically a rule violation? Yes. Does anybody have a stomach to prosecute that? Absolutely not. And I don't want to speak for the Office of Counsel. I don't want to speak for the Grievance Committee or the DHC, but I guess my gut reaction is I think it would have to be something where essentially the exigent circumstances are fraudulent. For the state bar to take interest in any sort of disciplinary prosecution. Carmen, you can probably speak to that a lot more, but I don't know how we resolve this saying, yes, you can do that when it does fit within the bounds of an ex parte communication outside of an amendment to Rule 3.5 that accepts this. But again, like to Carmen's point, does that suddenly create a window for folks to say, well, I had this emergency, and now we are in I guess we're in this spot where we have to actually vet the claim of emergency, because I very kind of easily could see a lawyer sending a complaint to the state bar saying, this person said they had an emergency. They absolutely did not. They were home with their dogs. They just didn't want to go out that day. And they not only lied to the court, but they actually did engage in truly ex parte communications. And that kind of opens up a different can of worms. And so that's where, in looking at this, I kept on coming back to this answer that technically it is a violation. And so the direction should be copy opposing counsel. If you're going to call somebody, copy opposing counsel. And maybe that's something that we need to clarify, that another option would be, if you cannot copy opposing counsel, send your message to the clerk, who then can disseminate that message to both the judge and the opposing party. Maybe that would be where a third party intermediary, even a court personnel, should be mentioned here. But I don't know how to not call this an ex parte communication. And that's where those last sentences are trying to remind folks that, you know, to kind of understand the circumstances. But I would love to hear everyone's thoughts on that.
This is David. It's when you mentioned earlier about there might be something different for pro ses, you know, as you know from our prior conversations, I do not have trouble with that. I think it's all the same. For this one, I would be inclined perhaps to, and I saw Mark's, I originally also, Mark, thought about perhaps deleting the entire inquiry, but it seems to me like this probably should end at however the rules of professional conduct are rules of reason. Because if a lawyer on the other side decides to file a grievance against you for this, I think the state bar, the Office of Counsel would look at this as a rule on that basis. I also think the court could do it on that basis. And I think that's just probably the way it is. I know in the olden days, I remember driving to Newton one time and the bridge was out at Granite Quarry or Granite Falls, whichever one it is. And I happened to know another lawyer, turned around and started driving back and happened to know another lawyer and pulled into somebody's office and called a lawyer in Newton and said, hey, how about going over and telling Judge Farrell that I'm not going to show until I can find another way to get to Newton other than Highway 16. And, I think I didn't call the court and the other lawyer was driving just like I was. This was pre-cell phone, so there wasn't any way to do anything. And I think you just have to say this is going to be a rule of reason and leave it there. I think the gloss that you add on there does sort of do the wink, wink, nod, nod, and I'm not sure we want to do that. I think including that sentence, though, reaffirms the way this would likely be handled by the Office of Counsel.
Thank you. And Colin, you indicated you wanted to say something. Colin, you're on mute, Steve. Oh, yeah, we still can't hear you.
Now, can you hear me now?
There we go.
Okay, thanks. I wanted to say that I really thought that your response in 4, the entire response was really good. I think you've taken on the Herculean task of trying to legislate good sense and professionalism, and that's a tall task. But I think you've left it up to the judge to whom this communication was made to evaluate it and decide if there should be further concern about it. And I think no one is better than she or he to say, was this necessary? Was their failure to contact someone else appropriate and understandable? And I think that adds context to the decision. And I really think it should be included.
Thank you. I noticed, Mark, you had opined in the chat that that perhaps this inquiry just should be deleted. Does this inquiry really add to the opinion? Is this something that perhaps we don't want to address? I'd like to hear some folks' thoughts on that.
Brian, this is Mike. Can I ask a kind of a fleshing out question about the inquiry itself? Jerry brought up a slightly different situation. That is, this inquiry, that is new inquiry number 4, used to be inquiry number 5. Is that what we're talking about? Right? Okay. This one is positing that the lawyer doesn't communicate simultaneously with opposing counsel because the lawyer has limited time. Jerry posits a situation where he doesn't have contact information for opposing counsel. It's not a time issue. It's a lack of information issue. And so, I tried to think, all right, if I'm Judge Sellers and a young lawyer comes to me with a hypothetical, just asking advice and saying, I'm in this situation, I don't have the other side's email, what would you think I ought to do? I might well give the lawyer advice that they ought to try and first communicate with opposing counsel, and and the judge simultaneously. If they can't, they ought to give opposing counsel notice as quickly as possible under the circumstances, or to make clear that you just didn't make a decision. I just didn't have time to, communicate with both. So I picked the judge. My hope would be that they would have a relationship with opposing counsel so that if they have limited time, the party they contact is not the judge, it's opposing counsel, and says, hey, Brian, I had a wreck. I'm not going to be able to get there. Would you mind communicating with the court for me and telling them my situation? I would hope we would have a bar that would do that as opposed to default. I'd rather talk to the judge than talk to opposing counsel about my scheduling issue. And I don't know whether that just overly complicates the situation. But I just, I wonder if we shouldn't be aspiring to more professionalism.
As Brian knows, I'm in favor of cutting things out almost all the time. So I'm taken with Mark's suggestion, honestly. I think if what we're saying is, you all may think there's an exception, but there isn't an exception. Why don't we just leave it alone? I mean, having stated what the definition of ex parte communications is, it may be appropriate to allow the rules of reason and the grace and the professionalism and the, just being realistic to play out in the real world without trying to articulate it here in a way that does, to David's point, look a little bit cute, I don't know. I think less is more a lot of the time.
Mark, you have your hands up.
Yeah, originally the question was, could you do it if you did copy counsel? That was the original inquiry 5. Now we flipped it to say you don't. I tend to agree that the technical answer is no, but the common sense answer is yes. But I think given this tension, I don't see a need to grapple with it because it's not really going to likely come up in a disciplinary context in this way. I worry that by giving it the no answer, we look unreasonable and cold. Giving a yes answer may be some kind of wedge, that people try to create emergencies. So I think this is one, we haven't really been asked this revised inquiry. I don't think we gain much by addressing it. And that's why my suggestion would be to just skip it. And I think we've dealt with a very hard question in the previous one, and we all agree with the way you've handled it. I do think that's something that we need to address on the ability to copy someone else where you're in this issue. So I'd be inclined to leave it out.
All right, I'm seeing some general agreement expressed in the chat. So if that's, does anybody have a contrary opinion where they would prefer to keep this in? I think, Colin, you would like to still keep it in. Yeah.
Just as a technical matter, Brian, the statement that the judge retains authority to determine the propriety of lawyer A's emergency communication as the judge deems appropriate. As you know, there are 2 tracks we're on, right? The state bar can do what it wants to do, regardless of what the trial judge may think is proper or not. That sentence is problematic for that reason in addition.
Mm-hmm.
Brian, I think that the thing I'm concerned about is we're discouraging someone from notifying the court of a legitimate emergency when they don't have the opportunity to notify opposing counsel. I mean, we say you can't show up in court, so you don't tell anyone because you can't tell opposing counsel, and so they go ahead and litigate the matter. And then when they find out tomorrow that you were providentially hindered and couldn't be there, we have to undo that and go back and redo it. And I still think having a little bit of discretion in the system and trusting judicial officials to respond appropriately is the default place to deal with exceptional conduct.
Thank you, Colin.
May I speak?
Carolyn.
And also I wanted to thank you so much for all of the work on this. And I know we've been doing this for a long time, but just my thought on including this hypothetical is I think it would be helpful to both lawyers and judges to know what the state bar thinks on this particular issue and what to do about it. But I do have the concern if you're in a car accident, you are trained as the lawyer, I better let the court know I'm not going to be there. So you want to do that, but then you have this obligation to let opposing counsel know, or what if it's a pro se opposing party? So if the thought is to maybe keep this in there, maybe some language that along the lines of what Judge Robinson was saying, that, if it's not possible to contact the opposing counsel, the lawyer should, as soon as practicable, or, you know, make every effort to communicate that information, or just something so that it's not like you get in an accident, you can only make one call. You know, you're in jail, you can only make one call, and you choose to call the judge. That doesn't mean you get out of jail and you don't have to do whatever else is appropriate. I just thought we want to encourage lawyers to do the right thing. And I liked the point that was made. We certainly wouldn't want to discourage them from reporting they're in an accident. And so to let them know what they should do if that happens, if that's, I don't even know how common a type of informal communication that is. Maybe Judge Sellers would know, or, I mean, hopefully it doesn't happen too often, but I think having some kind of guidance there is good. And maybe just some explanation that, look, if you can't, you know, we understand there's circumstances where you may not be able to reach or contact opposing counsel. You should still strive to do so either yourself or through someone under your direction and control. You know, I mean, I know there are solo practitioners out there who don't have an assistant answering phones, but you know, or maybe there's the folks without the cell phone, but just some duty to continue to try to get appropriate notice to everyone who's entitled to it. And I think that would convey the understanding that just if you can't make the call while you're in the stretcher going into the ambulance, that doesn't mean you're doomed. So I don't know, I'm not articulating it really well, but that was my thought.
Well, I think I'm wondering if maybe what we're talking about here is perhaps a different inquiry, and maybe perhaps a different question that we're asking. We're asking a question that produces a yes or no answer. But perhaps we ask the question as far as just a generic and really broad, what should a lawyer do? And therefore we could offer some general guidance on what a lawyer should do, encouraging the lawyer to focus their efforts. Yes, try to contact or copy opposing counsel, but that may not be possible, you know, so, but the responsibility, or I guess kind of work on the language there, to inform the court, you know, not just for your sake and for the court's sake, but for the client's sake as well, that you will not be there, but nevertheless to put this opinion in the encouraging, kind of the should sort of language. We do have that in some of our opinions. Of course, we would prefer to have yes, no, kind of clear parameters, but you know, this might be one of those where we don't want to answer yes or no. We just want to encourage lawyers to consider this variety of options in tackling that issue. And so to that end, what I'm hearing from everyone, I'm thinking maybe I should try to draft something that might be along those lines and send it out to this group and see if that's something that's satisfying our desire to have some sort of guidance here, but not necessarily, as I think as Mark very clearly and correctly put it, not addressing well, technically the answer is yes, but common sense says no, you know, that sort of thing, as far as whether this is an ex parte communication and something therefore that should be prohibited. What do you all think of that? Would that be acceptable? Should I make that effort?
I think that's a good idea, Brian. And in keeping with the history of this subcommittee, we wouldn't really want to end this FEO this afternoon, I don't think.
Or ever, apparently.
Never. All right. Well, I'll tackle that task and send that out by email. When I do send out by email, I would encourage you all not to reply all, because if we get simultaneous responses going on between a lot of folks, then we could potentially be violating the Open Meetings Act. Just send any sort of comments you have directly to me, and I'll inform the subcommittee of the consensus. And certainly we can get together again and discuss this. I have to recognize it's 4:15 right now. We were hoping to only go till 4, and there are 2 more inquiries to cover. What's the desire of the subcommittee, to keep going and see how quickly we can get through these things, or do we want to potentially just wait for another day?
Brian, I would think that if you're going to do that rewrite anyhow, that we may just want to take up the last inquiries afterwards.
Okay.
I think that the new inquiry number 5 probably pretty aptly captures what Marcy was her goal in this subcommittee to begin with over the last few years. So that inquiry
number 5 has not changed. That's the one that addresses
Correct.
The only thing that changed was removing the notice or the language of with proper notice to the opposing counsel. This is the one that addresses comments on the merits of the case are a violation of Rule 8.4D. So that has remained the same. Marcy, I see you have your hand up.
Can we just talk about the last one real fast, just in case you need to do any work on it? There's just one more, right?
Yeah, there is just one more. So yeah, this one, I'll just quickly, this one is a kind of a redone one because again, it had a domino effect, changing that what is now inquiry number, I guess, inquiry number 3. And this one is basically creating the situation where a judge has solicited communication on the merits of a case, which we have previously said is not permitted, that a lawyer can't just go ahead and do it. So this time a judge has asked for counsel to submit their arguments via email. And in light of the prior opinion, this inquiry asks, is that okay, since the judge has asked that? And the answer is yes, that essentially if a judge has authorized this, if the judge has requested you to send this type of communication, that again, judges are the ones that have the discretion to direct the types of communication that come to the court. And so if the court itself says, send your substantive arguments, we didn't get to your matter or whatever the case may be, but send your substantive arguments to me by email, that essentially that is the, I guess that's the trump card when the judge actually requests that type of communication. It is authorized, and therefore it's not ex parte, nor is it a violation of 8.4D. Yes, Marcy.
So Mike, do you in business court request arguments, substantive arguments, before a case is heard on the motion, or only after it's heard?
Marcy, we have a procedure on discovery matters where we require the parties to email the court through the law clerk and provide a description of the dispute. And the other side is permitted to respond in like kind, and then the court decides whether motion practice is advisable or necessary. And sometimes we have a phone conference with them and discuss the dispute, and sometimes we just say, this looks really complicated, file your motion.
Because in my world, what I wanted to add to this is after following a hearing, if the judge requests a proposed order and or your arguments, then it's okay. But in my world, you can't have anything that should be on the record. You can't do it by email. I mean,
well, let me give you a for instance or a hypothetical. It's my understanding that in many state court rooms in North Carolina, briefs are not a matter of record. That is, they're not, the rules don't refer to memorandum of law being filed with the court routinely. Counsel just hand up briefs
right
at hearings or mail them to the judge and opposing counsel before hearings. And I think this is just getting us into the 21st century and saying, rather than sticking it in the mail, if the judge says, email me your briefs the weekend before court so I can review them over the weekend and be ready, I personally don't see anything inappropriate about that.
Okay, so that's what this is. Okay, so arguments, this also is supposed to apply to proposed orders too, right? Should we add that? I mean, because this originally we were talking about proposed orders, that because we do that all the time. The judge says, okay, this week, Ms. Armstrong, prepare an order, send it to opposing counsel, and then then we'll send it to the judge. But I mean, I just didn't know if we should add proposed orders to that.
Yeah, I think we could. I mean, that's the intent of this opinion, is to say if a judge solicits this type of information, whether it's an order, a brief, even just send me the bullet points, even if it's after a hearing, send me the bullet points of your argument, or whatever the judge requests. That if the judge requests it, you can do it. You don't need to worry about the
and I'm going to. Every time.
Right. So we could add that. I'll do that as well, just kind of to kind of give a for instance, or, whether it's requested arguments, a formal brief, or a proposed order,
Right.
if the judge requests it, that, a lawyer should not feel that the rules of professional conduct essentially would prohibit the lawyer from complying with the judge's instructions.
Okay, that's good to know. Good job.
Okay. Well, then with that said, I know we went over time, but I appreciate everyone's thoughtful consideration of this. I'm going to make some amendments to what is now inquiries number 4 and number 6 and send that out to you all. And we will we'll see if we need to convene this group again to confirm a particular copy of this or a particular version of this opinion for potential presentation to the Ethics Committee in April. All right.
Hey, Brian, can I make one other observation? There was somewhere in one of these comments that we got from lawyers who said, if I have the judge's phone number, then certainly he wants to hear from me. Trust me on this, just because you might have my cell phone doesn't give you the green light to call the presiding judge. I know you know I'm preaching to the choir, but that was the funniest comment I saw in all of these.
I'm hearing inquiry number 7 and opinion number 7. I don't know if I want to put that in writing though.
Wasn't there one comment that said, was this coming from the judges because they don't want to be bothered?
Right. So yeah, that's well, nevertheless, I think we've covered a lot of ground here today, and I appreciate everyone here. Jerry, is there anything else you wanted to cover?
No, I think that's got it. I appreciate everybody attending. I very much do, and taking time.
Yes.
This has been an ongoing project, and it's taken a lot of time over the years, and we appreciate everybody taking time today.
Absolutely. And nice to meet you, Judge Sellers. Thank you for joining us. And yes, thank you, Mark and David, for stopping in, as well as to our officers. Always good to see you.
Yes.
All right.
Good to be with you.
All right. Thank you, everyone.